Deputy Hall, you might want to check that. Sure, thank you. All right, good morning, everyone. Welcome to the 4th District Court of Appeal. To my right is my colleague, Judge Robert Gross. To my left, my colleague, Judge Jeff Kuntz. We are prepared to go forward with the docket as scheduled. So the first case on the docket today is Morgan versus State.
Good morning. And may it please the court. My name is Frank Meister, and along with Michael Enton, we represent Bobeth Morgan, who is present in the courtroom this morning. I'd ask to reserve 2 minutes for rebuttal, please.
Yes, the yellow light will go on when you see the 2 minutes, okay?
Thank you.
Thank you.
Your Honor, this is an appeal from conviction after trial in Broward Circuit Court on a charge of aggravated battery. I do want to start with the first issue in the initial brief, and that is regarding the testimony of the arresting officer, the detective Eric Kurtman. And the essence of the first part of the appeal is whether the trial court allowed the detective to testify over Ms. Morgan's objection to his opinion that Ms. Morgan was guilty and commenting on her credibility, the credibility of her statement, and in so doing bolstering the testimony and his opinion regarding the named victim in the case, Nikisha Phipps. Whether the objection preserved the issue, and whether the error rises to the level of reversible error. If not, whether what subsequently happened in the trial, including closing argument, constituted fundamental error. So what was the testimony really at the heart of the appeal? On redirect examination, and that's important, it was redirect, the state stood up and asked their witness one last question. And the question was, after reading the reports of the other officers involved and seeing the injuries to both parties, who did you decide to arrest? The defense objected to relevance and made a short speaking objection, quote, he already testified that he made a decision to arrest her, Judge, it's not relevant. The objection was overruled and the detective was allowed to testify, Miss Morgan, I decided to arrest.
Well, wouldn't that be obvious to the jury that he decided to arrest Ms. Morgan because they're there for her trial? I mean, that's not a secret, is it? I mean, it's not like he gave an opinion as to, a lot of the cases there's an opinion that's given as to credibility of child victim witnesses and stuff. And here he was just saying, who'd you decide to arrest? But it's obvious who he decided to arrest.
It is, agreed. However, in the context of the trial, in the context of the direct testimony, it came out that Ms. Phipps had gone to the police department. Lots of other things happened first, and I'll talk about that in a second. Detective Kurtman, tried to get in touch with Ms. Morgan and couldn't do it, and so he arrested her. After she was arrested, she came, obviously she was brought into the police station, and he then took a statement from her, a complete statement, which the jury didn't get. The state moved in limine to exclude that as a self-serving statement. The state, however, elicited that testimony from Detective Kurtman during his direct examination.
Well, that's good for you, right?
That part of it was.
Right.
However, to then go back and say, after all of that, which clearly is telling the jury that that Kurtman had an opportunity to listen to Phipps, and he had an opportunity to listen to Morgan and inspect her injuries and everything else. To then go back on redirect and ask that question and get that answer, it's clearly communicating to the jury that he listened to both of their stories and he does not believe Miss Morgan. He does believe Miss Phipps.
Well, the question here is I get kind of your point. I mean, I see that it really wasn't technically relevant, but I'm having a hard time as to why it's even reversible error because the jury's, the state's prosecuting Ms. Morgan. I mean, so it's obvious that the state and the government and those people believe that she's guilty. I mean, otherwise they wouldn't be there. It's not like a surprise to the jury. But on the other hand, you have the benefit, and you can argue the presumption of innocence and the proof beyond a reasonable doubt and all those things that really the jury should take into consideration in deciding whether or not to return a verdict of guilty. So I'm really not seeing how this is not harmless error in the context of the entire trial.
Can I just tell the court This is how the state, in closing, evaluated that question and that answer. This is what the state attorney argued to the jury regarding that exchange.
But there was no objection to what you're about to tell us, right?
At the time of closing, there wasn't. It was interesting. I'll tell you.
I get it for the closing, but the absence of an objection really is problematic, isn't it? Doesn't it have to be fundamental error for there to be a reversal then?
And it is. When you combine what the state argued regarding Kirkman's opinion and this testimony regarding get rid of her, and we haven't talked about that. The state argued in closing, and actually it was the theme of their case because they brought it up in opening as well, that Miss Morgan went into the bathroom to get rid of Miss Phipps. And I read, obviously, in the state's response, they said, well, that doesn't evidence an intent to murder. Well, it does. They could have said lots of other things. They could have said that she went there to hit her, fight her, maim her, slash her. They didn't say that. 4 times in closing, the state argued that Morgan went into the bathroom to get rid of her rival, this theme of a love triangle. And that was never part of the evidence in the case, and it tends to inflame the jury and appeal to their passions and so on. When you combine the get rid of testimony with what they argued about Kirkman, and they argued as follows, please. They said, he told you that he reviewed first of all, they talked about what an experienced officer he was and his 12 years and everything else. And they said, he even was honest enough to tell you that he had a chance to speak to the defendant, Bobeth Morgan. And they go into what else he said. He came to one conclusion, that it was Nikisha Phipps who was the victim and Bobeth Morgan who was the perpetrator. That's the words that they used.
The defense in this case, though, relied on the officer who was on scene, who spoke to the defendant, called her as a witness,
Yes.
and then relied on her testimony during closing, correct?
Yes.
Okay. So this is kind of a unique case when you have one officer against another officer in a criminal case. Not that they're necessarily adverse per se, but they're obviously giving 2 conflicting opinions, or at least recounting different events as they understood it. So isn't this perhaps a case that deserves a little bit more leeway on what the state should be able to say, contrasting the testimony of this detective versus the testimony of the officer?
Contrasting, yes. But that question added nothing in terms of factual evidence. There is no forensic evidence in the case. There is no expert testimony in the case. It was 2 people in a bathroom with no other witnesses. All of the case law, and the case law cited in the motion, says that the error that is caused by allowing an officer to express an opinion as to guilt. And Crystal Smith didn't...
Let me interrupt you there. He did not express an opinion as to guilt. He said who he decided to arrest.
But she was already in custody.
Yeah, but that's again, that's what the case, let's be clear about this. The case law says expressing opinions about guilt, and you're making an inference that if he testifies who he decided to arrest, the jury, or making an implication, the jury is going to take the inference that that's what that means. That's not necessarily true. If you have an educated person on the jury, they're going to know that who he decided to arrest just means who he thought he had probable cause to arrest.
I would argue that in the context of how that played out, which was direct examination, cross-examination, and then redirect, it was very clear that the testimony was designed to inform the jury that after reviewing the whole case, Morgan is guilty and Phipps was telling the truth. And so if Morgan lied, if Morgan's guilty, then she lied in her statement. If she lied in her statement, then she must be guilty. When you look at the whole thing as a whole, and the clearest other indication is how the state viewed that testimony. And with regard to the question, well, it wasn't preserved because it wasn't objected to. The defense doesn't have to make, according to the case law, futile objections. So when Morgan's attorney stands and objects, it's not relevant, Judge, to what the officer decided to do after listening to all of the evidence, and it's not quite what happened, but he doesn't then have to keep objecting over and over again and repeating a futile objection. And the case was Stokes. It was a gang case. And the defense moved at the beginning of the trial that Stokes shouldn't be identified as a gang member. The judge overruled the objection. It came in throughout the trial. And this court in 2005 said objection at this point would have been futile based on the trial court's prior ruling. And I think to go on and on and on objecting.
Do you think, I mean, you think that you think that an overruling of the objection during the presentation of the case, and then sometime later, the argument that is made that's the showing of futility that that relieves the defendant of the responsibility of raising the objection before the judge? Isn't it usually that the objections are so close in time that that precise objection has been made and continued to objection is futile?
As I read Stokes, it was an objection that was made at the very beginning of the trial. Don't allow the state to identify my client as a gang member. That was overruled, and it came in throughout the trial. And this court said to insist that you continue making the objection. The court's already ruled, and again, I think it just highlights the testimony. But I also want to talk about fundamental error a little bit. The opinions, particularly the Supreme Court opinions that deal with this opinion testimony, and also it's at the same time it's very much a comment on the credibility of the two witnesses. They're the only two witnesses in the case. They have exactly the opposite testimony. Phipps said, Morgan struck me across the face with a bottle. Morgan's immediate reaction after the incident was she found a police officer. She said, I was attacked by Miss Phipps with a bottle. Miss Phipps then spoke to the officer. The cases read together say, number one, it's error to allow a witness to comment on the credibility of another witness, and error to allow the opinion regarding guilt.
But going back to what I think Judge Gross asked before, doesn't the fact that Ms. Morgan is the one sitting there at the defendant's table, when there's only two stories here, tell the jury who the detective believed? I mean, is there anything additional? Is there any added harm by the detective saying that when it's already obvious by the fact of who's sitting there?
In this case, what makes this case different than every other case where a detective or an officer says, I did an investigation, I made an arrest. Morgan was arrested without having given a statement. The officer sat her down and took a sworn statement from her that the jury never got. The jury never got that statement. And then, after all of that, the question was framed based on reviewing everything. Who did you decide to arrest? At that point, it changes it from all of these other cases that we ordinarily see, because then it is asking the officer to evaluate all of the evidence in the case, which the jury now knows includes Morgan's statement and Ms. Phipps's statement. And so that's why it's different.
In closing argument cases, the cases I'm familiar with that apply find fundamental error, find that there was an appeal to race, prejudice, hatred, and things like that. And I mean, it's the most extreme type of error that can't be allowed to happen in the court system. This just doesn't seem like that type of error. I mean, it may have been a correct objection, but it doesn't really get to the level in closing argument of that no verdict could be reached without, that type of appeal. So I'm not familiar of any closing argument cases finding fundamental error where there is the error, if there is an error, is as flimsy as the one you're raising in this case.
I find it impossible to imagine, impossible to believe, that the jury did not go back and during their deliberations say, that guy, Detective Kirkman, especially Kirkman. Kirkman's a sharp guy. He's young, and he's clever, and he has an air of credibility. I like Kirkman. I find it impossible to believe that they didn't go back there and say, this guy's pretty sharp. 12 years as a detective, violent crimes detective. He says she's the perpetrator. And that's what the state argued. The one objection that did come during closing argument was the state went beyond the word perpetrator, and they said, it's Kirkman's opinion that she was guilty. Objection sustained, and then they went back to this argument about perpetrator.
But for fundamental error, wouldn't the test be that if, assuming that they couldn't have reached that verdict, that's, I mean, fundamental, they couldn't have reached that verdict unless that argument had been made. I mean, if the state had a perfect closing argument, couldn't they have reached the same verdict?
They could have. The error was preserved. It is appropriate to consider both the preserved and the unpreserved errors under Gore in determining whether the preserved error was harmless beyond a reasonable doubt, which there's no way that was harmless beyond a reasonable doubt, that there's certainty that the jury never considered it during their closing arguments. But when you put that error together with with this get rid of, the theme of their case was that she was trying to kill the other woman, that does reach the level, I would argue, of fundamental error, that it reaches down into the validity of the trial.
Our questions took you past your rebuttal time, but we'll be happy to give you some rebuttal time.
Thank you, Your Honor.
Thank you.
Good morning, may it please the court. My name is Richard Valentis, and I represent the state of Florida. I believe Judge Gross and Judge Kuntz hit the nail on the head. I mean, just by the very fact that someone is sitting in a defendant's chair, that's indicative of, that's who the police believe they had probable cause to arrest. And as Chief Judge Gerber pointed out, just the fact that you were arrested does not equate to an opinion of guilt. And those are two different things. In this case, I believe during direct, the detective testified that he had already placed her in custody. So that evidence was already out there, and again, by the fact that she was sitting in the defendant's chair, showed that this was the person the police believed committed the crime, and that's why we're going through the trial and through the entire judicial process. And I don't think it was, not an important part of the test. It wasn't just a he said, she said. We did have the instances beforehand where the defendant tried to attack the victim's boyfriend on 2 occasions and then ultimately ended up attacking the victim in the bathroom. And the victim's version was, I got bashed in the face with a bottle, which is borne out by the scars and all the injuries she sustained. And the defendant's version was, no, she attacked me and actually just fell and got all these injuries. So that was an issue that went to the jury, and I don't think, as Judge Gross pointed out, this would come anywhere near close to being harmful error whatsoever. And in fact, the relevancy objection raised by trial counsel below indicated that he even knew it was cumulative because the detective had already testified to that. Regarding the closing arguments, there were no objections until, as opposing counsel noted, when guilty or opinion was brought up, objection sustained, no request for a curative, no request for a mistrial.
Well, what is your response to his statement that the continued objections would have been futile?
Absolutely not. As a matter of fact, the fact that that evidence had already come in, Judge Kuntz, which is, hey, we took her into custody and then we got her statement, the jury already knew that the police decided to arrest her. So I don't understand. The question really doesn't make a whole lot of sense because, well, after you reviewed all the evidence and you did all that stuff, well, we already know from his testimony that she was arrested. So at best, it would be harmless error. And as reflected by the objection made by trial counsel, which was cumulative. As far as the stuff in closing argument, this whole notion that murder was somehow an intent, that's obviously not the state's position. The intent was the victim and the boyfriend were together, and during their relationship, the defendant had an affair outside of that relationship and had a child with the boyfriend, okay? And she felt neglectful and that the boyfriend was neglecting his child with her, and she was trying to scare off her romantic rival because she obviously wanted the boyfriend for herself. That was the state's position. This whole murder thing was not anywhere close to argued below. If the court has any questions on any of the other issues or issue 1, The state would request you affirm.
Thank you.
Thank you.
Brief rebuttal, please.
There was no other purpose for asking the question. They've been through the whole case. They've been through all the facts of the case in both statements. The state was just cleaning up at the end after cross-examination and after everything else that you heard, Detective Kurtman. What did you decide to do? But it's clearly not adding a single other fact to the case. They didn't bring in any other statement during this exchange. They only wanted to ask that one question. And then having asked the question, the objection was relevance, which was the correct objection. It was overruled. It's preserved. And then having got that in, the state then hammered that in closing argument. They made that a feature of the argument, basically telling the jury, you should trust Detective Kurtman. How do we know she did it? Because Kurtman told you she did it. And so that's why it's different than just any other case where the officer says, I did an investigation and I made an arrest. There is a recognition that juries give great weight to police officers' testimony. It is especially harmful for a police witness to give his opinion of a witness's credibility because of the great weight afforded an officer's testimony. Because of their positions, their testimony brings an air of authority and legitimacy. A jury is inclined to give great weight to their opinions. And that's what happened in this case.
Thank you.
Thank you, Your Honor.
Thanks to both sides. Have a good day.
Thank you.
Next case on the docket, McGraw versus State.
Given the option, I will take it. Your Honors, Benjamin Eisenberg on behalf of the appellant Byron McGraw. I'd like to reserve 3 minutes of my time for rebuttal. We're here today on a certified question of great public importance from the county court related to the constitutionality of a provision of Florida's implied consent statute, which permits officers to perform blood draws on persons suspected of DUI who have been rendered unconscious and are receiving treatment in a hospital. The trial court correctly ruled that the blood draw performed in this case violated my client's Fourth Amendment rights because Officer DeSantis did not obtain a search warrant, no exigent circumstances justified his failure to obtain a warrant, and implied consent is not the equivalent of Fourth Amendment consent. The trial court, however, erred by applying the good faith exception to the exclusionary rule to deny my client relief.
Let's go to that issue, which I think is a problematic one. In Birchfield versus North Dakota, and Justice Alito's majority opinion at footnote 9, he refers us to Hyen versus North Carolina. He says when it goes back on remand, they're supposed to consider this blood draw case anyway under the principles of Hyen versus North Carolina. And this is a case where, let's say I spent 25 hours last week working on the case, and I've been doing criminal law for a significant number of years. In Hyen, the Supreme Court held that an error of law was sufficient, a good faith error of law was sufficient to justify the application of the good faith exception. Here we have a statute which, at the time the officer was dealing with it, plainly authorized what he ordered, an unconscious defendant in the blood draw. And there was no express case holding that statute was either unconstitutional or should not have been applied under those circumstances. So isn't that precisely the type of error in law which the Supreme Court contemplated in Hyen versus North Carolina?
No, Your Honor, I disagree. Hyen wasn't decided in the briefs, but I am familiar with it. I believe that was a situation where there was a statute which was in and of itself a bit confusing, and the officer could have, at the time it was not judicially interpreted, but he could have interpreted it reasonably the way that he did to justify the Fourth Amendment search. So that's what the situation was. You had a statute which itself could have been interpreted reasonably by officers in multiple ways. So the officer reasonably interpreted it one way to perform the Fourth Amendment stop, and then it turns out that the court went the other way. So in that type of situation, the good faith exception would apply because the officer was acting objectively reasonable. In my case, you had a very different situation. First off, you had Missouri versus McNeely, which issued in 2013, 3 years before the search in this case. And in Missouri versus McNeely, the United States Supreme Court stated, rather bluntly, that the exigent circumstances are not satisfied by the dissipation of alcohol alone, and that is only one factor in the totality of the circumstances analysis. So in that regard, he clearly couldn't rely on exigent circumstances. Now, as importantly on the issue of consent, of which this was the argument below, and both on appeal, is that the statute, in this case, the implied consent statute, authorized the search. However, in 2015, the Fifth District Court of Appeal in Williams v. State decided, and I quote, that statutorily implied consent is not equivalent to Fourth Amendment consent. That was not specifically limited, but even if it was, Williams v. State was decided in 2015 and addressed a warrantless breath test.
But they, in Williams v. State, they were not addressing the precise subsection that is involved in this case where you have an unconscious defendant, were they?
Well, no, they were addressing the same statute. It was section 316.1932, but it was subsection 1A and then little 1A.
So what you're saying is that what you want us to find here is that if there's a Supreme Court case that generally talks about, a different situation, and if there's a Florida case that talks about a different subsection of the same statute, that we hold that the officer should have been familiar with that level of case law and should not be able to rely on the plain language of a clear statute which authorized what he did.
And
because
this
we're
is-
holding them pretty much to a higher standard
I
than
don't
we hold
believe it-
prosecutors and judges.
I don't believe that that's that highest standard when you have a case that plainly states statutory implied consent is not equivalent to Fourth Amendment consent. When you're an officer and you're going to seek to apply implied consent, you have to think of that the case law, which then says, quote, statutory implied consent is not equivalent to Fourth Amendment consent. How can an officer reasonably rely on implied consent when a decision says that so plainly? And there were two decisions by that point. There was Williams v. State, which issued a year before the search in this case, and there was also State v. Lyles, which again was a different provision of the statute. However, in State v.
But didn't that deal with conscious defendants who were, who were able to interact with the police or make a decision on implied consent? Didn't both those cases deal with conscious as opposed to unconscious defendants?
Both of them involved people who were suspected of DUI, who were conscious. In Lyles, the defendant specifically refused consent. However, the proposition is very broad. Statutorily implied consent is not the equivalent of Fourth Amendment consent. I want to address the issue of the good faith exception. I want to discuss a case that was
Let me ask
decided.
you, Birchfield wasn't, make sure I understand, Birchfield had not been decided at the time of the arrest in this case, had it?
No, Birchfield was decided a few months after the arrest in this case. However, Birchfield has language which supports that implied consent would not be the equivalent of Fourth Amendment consent. In that case, for example, the state was arguing for a per se rule that a blood draw would be admissible as a search incident to arrest. And the United States Supreme Court stated that it had approval of implied consent statutes to the degree that you had evidentiary principles, such as you can use the fact that they refused against them, or to the degree that at the same time, you could have administrative remedies, such as losing your license. But in that case, they said forcing someone to have implied consent on the pain of criminal prosecution was too much. And on the same regard, forcing someone to waive a Fourth Amendment right in order to be able to drive is simply too much. But I also want to address on that issue the Florida Supreme Court's recent decision in Carpenter v. State, which issued after they filed the initial brief, but is addressed in the reply brief. And Judge Gross, you're very on point with this, that it is a difficult conception for law enforcement. However, you have to look at the standard that the Florida Supreme Court expects them to know as well. In Carpenter, you have a situation where the First District Court of Appeal decided a case, Smallwood 1, I'll call it, and that authorized a warrantless search of cell phones. In the opinion for Smallwood 1, the First District certified a question of great public importance. The Florida Supreme Court accepted review of the case and eventually quashed it. In the interim, after Smallwood 1 was decided, but before Smallwood 2 was decided, officers relied on Smallwood 1 to perform a warrantless search. When it was deemed unconstitutional, they argued that good faith exception would apply because the only case on the matter was a First District Court of Appeal decision which was on point and controlling. And the Florida Supreme Court in Carpenter said that good faith did not apply because the Smallwood 1 decision stated on its face that it was a certified question of great public importance, so they should have known, the officers, that that wasn't final, that this was still a questionable area of law. Now, the Florida Supreme Court contrasted that from the situation in Davis versus United States, was one where officers relied on binding 30-year precedent to make a search, and then the search was eventually invalidated by Arizona v. Gantt. That was a situation where the officers did what they were supposed to do. They were relying on 30-year precedent. But if officers are supposed to know that, an opinion that certifies a question of great public importance cannot be relied on, I think officers should also know that case law, which says statutory implied consent is not equivalent to Fourth Amendment consent, they have to say, well, then I can't rely, or at least I'm running a risk by then relying on statutory implied consent. So that's my position onto that. As to the issue of whether consent, the state cites two out-of-state cases for the idea that, at least as applied to unconscious defendants, implied consent can be sufficient for Fourth Amendment consent. However, as I cite in both the initial brief and the reply brief, this is by far the minority position, and it makes sense. You know, the United States Supreme Court has decided two cases recently, McNeely and Birchfield. And in both of them, the state wanted to apply per se exceptions to the warrant requirement. In both situations, the United States Supreme Court said no. In McNeely, we were discussing a situation where exigencies, and the state wanted to show that the natural dissipation of alcohol would in itself create an exigency. And the United States Supreme Court said no. And in Birchfield, it was a search incident arrest, which is a per se exception. And the United States Supreme Court said no. And both these decisions were predicated on the intrusive effect of blood draws, the fact that you are piercing someone's skin, taking a part of their body out of them, and the fact that that part of their body can also be stored for future use. It's an incredible intrusion that cannot be justified on a per se basis. And it makes it hard to believe that the United States Supreme Court in the last few years would decide these cases and denounce per se rules only to allow implied consent statutes, which have been enacted in all 50 states, to swallow the entire Fourth Amendment jurisprudence and create a per se exception. It also opens Pandora's box because it would allow situations where you have people who are driving, which is pretty much necessary in areas such as South Florida, but you have to waive Fourth Amendment rights to do so. And also it's supported by language in Birchfield, which said, and I quote, "It is true that a blood test may be administered to a person who is unconscious or who is unable to do what is needed to take for a breath test due to profound intoxication or injuries. But we have no reason to believe that such situations are common in drunk driving arrests, and when they arise, the police may apply for a warrant if need be."
How do you respond to Justice Alito's statement in Birchfield that says our prior opinions have referred approvingly to the general concept of implied consent laws that impose civil penalties and evidentiary consequences on motorists who refuse to comply?
Well, I think then you have to follow that up with that he denounced it as applied to when you have implied consent that forces people either to submit or face a crime. The Supreme Court is okay with situations where, as you just said, where someone could lose their license for a few years, or someone could have an evidentiary presumption, such as the fact that they refuse can be used against them in court. Those are permissible. When you start crossing into the grounds of waiving Fourth Amendment rights, constitutional rights, or becoming criminally prosecuted, the United States Supreme Court specifically said the latter step was too far, and that was because of the invasive atmosphere of blood draws. But let's take a look at and I just want to point out for the good faith exception, again, that line, statutory implied consent is not the equivalent of Fourth Amendment consent. Here we have an accident that occurred, a single car accident that occurred at around 7:30 a.m. on a Tuesday. Officer DeSantis arrives at the scene a little after 8 a.m. while my client is being extricated from the car. He smells alcohol and providing him with probable cause, but he makes no attempt to obtain a search warrant. Instead, he follows my client to the hospital and orders the nurse, after some time trying to wake him up, to perform a blood draw at around 9 a.m. So you're talking about an hour, if not less. After he arrives at the scene, he orders the blood draw. This is not an unwieldy time. This occurs at between 8 and 9 a.m. on a weekday. The state presented no evidence it would have been difficult to obtain a search warrant, and there had already been case law which states that implied consent is not the same as statutory consent is not the same as Fourth Amendment consent.
Before you move on from those facts, do you, assuming that, taking out whether the implied consent violates the Fourth Amendment or whatnot, do you agree that the elements of 316, 1932, 1C were met?
It wasn't the subject of the trial court's order. I believe they were because my client was unconscious at the time. It would have been impractical to do a urine or breath test because he was unconscious. You do need to blow a certain force into the breathalyzer, and I believe to take a urine test, you'd have to use a catheter. That's very intrusive in its own right. And so I believe that the circumstances were met pursuant to the statute.
And you aren't disputing that he would have had probable cause,
No, I'm not disputing that in this case. But the situation, I just want to contrast one more thing before I go, which is State v. Lyles, which the trial court relied upon to apply the good faith exception. That was a very different circumstance because that case, the accidents occurred in 2011, which was prior to McNeely. And at that time, Florida law specifically dictated that there was no constitutional impediment to blood draws. Anything above that was merely statutory. So the officers prior to McNeely would have had no reason to contest why they couldn't apply implied consent statutes. But in our case, it was both after McNeely and after Williams. So the officer should have known that the dissipation of alcohol was not an exigent circumstance, and the officer should have known they couldn't rely on implied consent. If there are no further questions, I'll reserve the remainder of my time for rebuttal.
Thank you, Mr. Eisenberg.
May it please the court, Richard Valentis on behalf of the state of Florida. As Judge Gross pointed out, this is a situation where clearly the good faith exception applied. I looked this morning, and at least as far back as I was able to look at Westlaw, this specific provision about unconscious drivers goes back to at least 1988. So we've got, almost 30 years of a statute that has been unchallenged, that the police have been able to rely on, that says, hey, if we have a situation where there's probable cause for DUI, someone is unconscious, and they've presented at a medical facility for treatment, you can draw their blood. And then you flash forward to what the defense...
That first one is the key. I mean, there have been challenges to the statute, and whether there was probable cause, et cetera. But they can see there was probable cause.
Well, and when you get to the case law they're relying on, Judge Kuntz, it's this Williams case, which is interesting because then they cite Carpenter and says how it was in a state of flux. But we have to look at the Williams case that they're relying on because at the time of this incident, Williams, first of all, was not anything that was resolved in the law. As a matter of fact, I don't think it's applicable at all because it doesn't deal with this specific statute. But secondly, that was something that was pending review in the Florida Supreme Court. So bringing up Carpenter is interesting because under Carpenter, no police officer would be able to rely on Williams because Williams was specifically going before the Florida Supreme Court. It went before the Florida Supreme Court, and what did they do? They actually vacated what happened in Williams. So Williams is a nullity, and it has no basis whatsoever in this case.
So if I understand the state's position correctly, in order for this good faith exception to be nullified, either this court or one of our sister courts or the Florida Supreme Court or the U.S. Supreme Court would have to say expressly that this statute is unconstitutional.
I don't know if it's even at that level, Your Honor. If there were a trial court of competent jurisdiction, I could see a circuit court order, and then, of course, that would be taken up through the process. But what we have on this record is no Florida court of competent jurisdiction saying that this specific provision of the Florida statutes is unconstitutional.
So we do have a question by the United States Supreme Court. I mean,
Pardon me?
not the specific statute, but we have, I mean, in Birchfield, they say that applying this, we conclude that motorists cannot be deemed to have consented to submit to a blood test on pain of committing a criminal offense.
Correct. We don't have a criminal offense in this case, so that makes it completely distinguishable. And as Judge Gross pointed out in the language in Birchfield, they specifically said, hey, we've recognized these implied consent laws in the past, And nothing we're doing here today is undermining that.
Well, let's go to other dicta that Justice Alito has said in his opinion. And for us, we're required to follow the Fourth Amendment as construed by the United States Supreme Court. So we're always
Correct.
holding our finger up and seeing which way the wind is blowing. But Justice Alito says that it's true that a blood test, unlike a breath test, may be administered to a person who is unconscious or who is unable to do what is needed to take a breath test due to profound intoxication or injuries. But listen to this. He says, but we have no reason to believe that such situations are common in drunk driving arrests, and when they arise, the police may apply for a warrant if need be.
If need be.
Isn't that, but there's no exigent circumstances here. So there's no exigent circumstances. They've ruled out the arrest exception, the incident to arrest exception. There's no exigent circumstances. The trial court found that. So it seems to me that that's a clear signal to the country that in unconscious situations, unless there are exigent circumstances, that, you know, a warrant needs to be applied for.
Well, then that doesn't make, to me, that doesn't make any sense. Then why even bring up the whole implied consent and adhere to them? Because that's basically saying implied consent laws do not apply.
Well, because they're
and we're
talking-
not upholding them because
No,
in
but
this
they're talking about in the implied consent. They're talking about the notion that you can, you know, condition or you can't have a threatened criminal acts to override the consent, but you can, they're saying, have administrative, you know, penalties for the failure to take the blood test. And in that sense, you know, the court recognizes that implied consent laws are valid. But here, it seems to me, this is the language of the opinion that applies to the unconscious defendant. It's a pretty clear sign to us that they have, to me anyway, that they need to get a warrant unless there are exigent circumstances.
Well, I would disagree, first of all, like I said, because of the fact that they, you know, unequivocally said, first of all, it wasn't the issue that was before the U.S. Supreme Court. That's without a doubt.
But it's Justice Alito dicta. I mean, it's not Judge Gross
And he is
dicta.
a Philly fan, so he should be given a lot of weight. But the fact that they used warrant if need be, to me, is the critical language, because if, as you're saying, Judge Gross, if that's truly what the court was saying, then they don't even have to say if need be. It's got to be a warrant, period, unless we're talking about exigent circumstances. But exigent circumstances are already out there, and we know under exigent circumstances, because of what they held, you can't force the blood draw. So why, I don't understand why they would include the superfluous language if need be. They'd say a warrant is needed under X, and that's not what they said after they endorsed the implied consent laws. And that's, you know, my position. And then again, this is a situation where we do have a statute that was followed by the police for decades. And again, the Williams case is no longer a case. It's been vacated. And again, it dealt with breath tests as opposed to blood tests. And Lyles, which came out, you know, just a few days before this incident, I don't think it's reasonable for any police officer to be going through case law and saying, oh, well, I, as a beat officer on the street, am going to apply what the 5th DCA did in this case to something that happened down here, and I'm not going to be able to do this anymore. And again, Lyles is another case they tried to take up to the Florida Supreme Court. So I don't necessarily know how binding that is.
So if we say in this, just hypothetically, if we say in this case that in a situation where you have an unconscious defendant, probable cause, and the statute's otherwise been satisfied with, but in the absence of exigent circumstances, it's necessary to apply for a warrant, you know, the decision of this court would be insufficient to require it to be followed, and the police could still follow the statute that's on the books. Is that what you're saying?
Well, if you were to do that, first of all, it would be going against prior precedent from this court and the Supreme Court saying we're unnecessarily deciding a constitutional issue when it's not necessary because we can resolve it under the good faith exception. But then secondly, it obviously will be up and pending before the Florida Supreme Court, depending on whether mandate issues. I mean, of course, it would be prudent law enforcement practices within the jurisdictions to follow what the court has said. But again, as the defense brought up in Carpenter.
But wait a minute. Let me just I'm trying to understand what you just said. If we decide that the good faith exception does not, we don't reach the good faith exception unless we find a violation, a constitutional violation.
That's not necessarily true, Your Honor. You can decide it and say,
But if-
assuming for the sake of argument that there was a violation, good faith applies, that's the case. And that's what the Supreme Court and this court commands the court to do, because you have to respect the decision of the legislature in creating this law. And if there's any way that you can resolve this case outside of passing on a constitutional issue, the court's required to do it. And unless you find that there is no good faith exception, then obviously it's fair game to go into the constitutionality of the statute. But that's not the way this court's precedent, the Supreme Court's precedent works. It's the courts don't unnecessarily pass on constitutional issues, and that's just black letter law. So if the court were to go answer this certified question unnecessarily, then, I mean, that's going contrary to binding precedent. As far as the implied consent, in my brief,
One
I
thing, if we're
cite,
not going to answer the certified question, should we discharge jurisdiction?
that could be one option, or just affirm the result, which was that the blood test was suppressed because of the application of the good faith exception, and wait till the issue is properly before the court, and the court necessarily has to decide the questions. The court shouldn't be fielding questions or rendering advisory opinions on laws the legislature passed when it's not necessary to do so. And I would also, because of current events, direct the court to, it's a case that was cited in both Birchfield and McNeely. And the defendant keeps bringing up, Williams says implied consent isn't equivalent to Fourth Amendment consent. And I would say that's not necessarily the case. As a matter of fact, the case I'm referring to is from the United States Supreme Court is Skinner. And Skinner was a case where the administrative agency in charge of the railroads applied a rule. And the rule says if we have an incident or questions or whatever we have, certain of you folks involved in the railroad industry, we're going to come in, and not only we, the federal government is requiring the employers to come in and do breath and blood tests and whatever we deem necessary. And that's under circumstances, not like the recent train crash we had, but any type of incident without any probable cause or suggestion whatsoever that anyone was impaired. They're allowed to go in and force those blood draws. And under those circumstances, which again is obviously for protection of the public in transit, if that's been upheld by the U.S. Supreme Court, I don't see how, when you have a situation in Florida, under very narrow circumstances where you have someone where there's probable cause to believe they're under the influence, they are so out of it or injured and unresponsive that they can't even revoke the consent they've already given by driving on Florida's roadways, and they're presented at a medical facility for treatment. So they've got injuries or something's going on where medical professionals have to look at them. Under those circumstances, and particularly in light of Skinner, I don't understand how this provision of Florida's implied consent law would be unconstitutional.
But am I understanding you correctly? You're saying Lyles was wrongly decided by the Fifth District?
I believe Lyles could be, when you take in it, Lyles didn't mention Skinner at all, but I do believe it was ultimately rightly decided because they applied the good faith exception and said what the officers had at that time. Again, we can't have officers out on the street with case law going here, case law going there, and a statute directly on point, as Your Honor pointed out. There's nothing really for the law enforcement officer to do other than follow the dictates of the legislature as pronounced in the Florida law. The court doesn't have any further questions. The state would request you affirm and not address the certified question. Thank you.
Thank you, Mr. Valentis. Mr. Eisenberg, rebuttal.
I just want to quote first from the Florida Supreme Court's decision in Carpenter, which says, quote, "The rule on searches in questionable areas of law is simple and unequivocal. Get a warrant." That's what the Florida Supreme Court was telling us in Carpenter. If there's a question about whether the statute is constitutional, the officer should err on the side of getting a warrant. I want to discuss the procedural posture a bit of Williams. opposing counsel was trying to differentiate on the ground that that was a case pending at the Florida Supreme Court. Well, Williams was decided and raised questions about the application of implied consent. And so at the time of the search in this case, which was April 2016, Williams was still in effect. It wasn't actually quashed until November 2016. So it was pending before the Florida Supreme Court, and it absolutely should have sent up red flags to any officer about applying implied consent. I also want to talk with Judge Gross with regarding to your language of if need be. That was what they discussed in the Birchfield opinion with the Justice Alito dicta. Well, all states have implied consent statutes. Both McNeely and Birchfield recognize that. So if implied consent were to devour the Fourth Amendment rules, then that would have just been it. There wouldn't be an if need be. There would be implied consent applies all the time to justify warrantless searches. So that would be the end of that. It's clear that the if need be refers to exigent circumstances.
How do you respond to Mr. Valentis' argument that if we find good faith, the good faith exception applies, that we would be wrong in reaching the constitutional issue and we should discharge jurisdiction?
Good faith doesn't come into play until the Fourth Amendment issue has been decided. Just look at State v. Lyles. They didn't jettison the Fourth Amendment analysis simply because the good faith exception applied. And that's really the whole point of the good faith exception. Your honors need to render an opinion on the Fourth Amendment. If there is a Fourth Amendment violation, then that will inform officers that they cannot perform the search as done in this case. So you absolutely should not discharge jurisdiction if only for that grounds. But again, the analysis is not, let's just skip whether or not there's a Fourth Amendment violation because we think that the good faith applies. You have to address the Fourth Amendment question. That's exactly how Lyles approached it. Lyles said, was there consent? Was there exigent circumstances? No, there's unconstitutional. So now let's move on to the good faith exception. That's how the analysis has to perform. And I would just point out from a logistics perspective, we already briefed it at the stage of oral argument to discharge jurisdiction. We would have to remand it to the circuit court for more briefing and more decisions. I don't think that would be practical, and I don't think it's proper given how the good faith comes into play. So if your honors have no further questions, I ask that you reverse and remand. Thank you.
Thank you, Mr. Eismark. Thank you to both sides. Have a good day. Next case on the docket, Target versus Coffer.
I find it distracting to look at the Chief Justice's picture. It's like he's looking right at me.
Proceed. Thank you.
Good morning.
Morning.
John Deravere and Shirley Jean McEachern. On behalf of Target, I would like to reserve 5 minutes for rebuttal and response to the cross appeal. The facts in this case are undisputed, but they are somewhat significant and important for the court to consider. This is an incident that happened at the Sawgrass Target down in Fort Lauderdale back in 2010, just before the new statute was amended, the 768.0755. Mr. Coffer, it's undisputed, slipped in liquid detergent at the front of the store moments after a customer spilled the detergent on the floor. Mr. Coffer never testified that he could not see the detergent, nor did he testify that he was looking at the floor just prior to the incident occurring. All of the witnesses in this case testified they were able to see the detergent. They described the spill. Based on the record evidence, Target asserts that it's entitled to a directed verdict. It was entitled to a directed verdict as a matter of law. And the primary basis for that is that the dangerous condition that caused Mr. Coffer to fall was the detergent. That is the dangerous condition. Have to give Mr. Spatzer, who is here in the courtroom today, some credit for dealing with difficult facts and doing a kind of a workaround around the statute as it existed at the time, 768.0710, by making the floor the dangerous condition rather than the detergent. Unfortunately, under the case law that pre-existed this case and under the statute, it is the detergent that is the dangerous condition. And for that proposition, we have cited Calvacci versus Jackson Memorial Hospital. That's a 3rd District case back in 1991, where the court, in a somewhat analogous situation, and again, this was pre-768.0710 that we know overturned the Owens decision, Owens versus Publix. But the court in Calvacci says, second, we cannot agree that the defendant's employees created the dangerous condition by waxing the floor upon which the plaintiff slipped and fell. The dangerous condition in this case was not the waxed hallway, which indeed the plaintiff and others were able to traverse without incident. Non-skid wax was used to wax the hallway, and there's no indication of any waxy buildup or slipperiness in the hallway outside the place where the clear liquid is located. The dangerous condition herein was therefore the clear liquid in the waxed hallway upon which the plaintiff slipped and
Yeah,
fell.
well, let's change the simple fact of this, however.
Yes.
Let's say that what the liquid was, instead of being clear,
Yes.
it was black. So standing out on this bright, high-gloss, white floor
Yes.
is a big black spot.
Yes.
The plaintiff in this case testified that he was looking towards the cash registers, so perhaps he wouldn't have seen it, but it would seem more likely that there's a big black spot in the middle of a white floor as opposed to something that can't be seen because it's clear on a white, high-gloss white floor. That would be less distracting to him.
Indubitably, unquestionably, and that's part of the other problem, which is that you got to have some testimony regarding what is the standard for the floor. But under the statute 768.0755 or 0710, it doesn't matter what the substance is. It just matters whether the defendant, the retailer, put it there. Under the 2009 statute as it existed, the question is whether or not the retailer was negligent in its manner of operation that allowed the liquid to be on the floor. And what's really happened here at the end of the day, again, great credit to plaintiff's counsel, is...
But isn't my understanding, it wasn't that it's not negligence in allowing the liquid to be on the floor, because, liquid's always going to be on the floor in
Sure.
stores. But it's that the combination of the lighting and the high gloss, whatever they had on the floor, prevented it from being seen by a customer, and that's why they fell. It wasn't. It anticipated the existence of liquid on the floor, and said, look, in a better set of circumstances, it would be more visible.
Right. But what we've done there, and I think you accurately depict what the plaintiff's argument was, is we take comparative negligence and we flip it on its head and make that liability. So certainly, if you can't see a substance, then the argument would be you can't avoid it, so there's no comparative fault. But just because you can't see it, whether you can see it or not, or whether you're looking or not, under the statutes that we've got, it doesn't really matter what your comparative fault is. It matters whether under the old statute, the statute that was involved here, as to whether or not the retailer was negligent in allowing it to be there. And that's back to Judge Gerber's question. Does it matter if it's a black liquid? Does it matter if it's a banana? Does it matter if it's lettuce? Does it matter if it's a grape? The problem in this case is that and let me go back for just a second. What's significant here is that the coffers did not proceed under the statute, under 768.0710. Understandably, they didn't want to do that because that gets us to whether or not Target caused the liquid to be on the floor, was negligent in allowing the liquid to be on the floor. So what they've done now for the very first time in this case on appeal is that they have asserted a mode of operation argument. Target would argue that you can't just get around the statute because by this court's determination in the Pembroke Lakes case versus Magruder, that 768.0755, the new statute, is substantive, creating substantive rights. The old statute likewise would be substantive, creating substantive rights and obligations by effectively overturning the Owens case. So what we've got is a situation here where the plaintiff, the Coffers, for the first time have asserted this mode of operation theory. There is no argument, there's no reference in any way, shape, or form to negligent mode of operation in the complaint, and there was no negligent mode of operation issue provided to the jury. In other words, there was no jury instruction on negligent mode of operation. There was no question about negligent mode of operation. That is a manufactured issue on appeal for the first time. And the case law that we would cite for the fact that a negligent mode of operation case must be specifically pled is a federal case, but nevertheless, I think it's instructive. It's the Cacciamani versus Target case that very succinctly indicates that you've got to demonstrate negligent mode of operation and what the negligent mode of operation is that caused the liquid to be on the floor. That's the other problem, ultimately. Even if the Coffers were able to assert a negligent mode of operation case, when you look at Markowitz versus Helen Holmes, that's grapes on the floor, you look at Glaze versus Worley, Weil, the other cases, Markowitz is a great example of the argument that the negligent mode of operation allowed the dangerous condition to be on the floor. In Markowitz, there were grapes on the floor that were presumably dropped by residents of an old folks' home, and the testimony came in that the Helen Holmes allowed residents to walk their food back to their rooms. So it was foreseeable that that mode of operation, allowing people to carry their food and having people drop food, would end up causing the dangerous condition on the floor. Ultimately, in this case, in order to get a negligent mode of operation claim to work, the hypothetical would be that there has to be something about the way that Target stocked the detergent or put the detergent up. So for instance, if Target did something that caused detergent bottles to leak, and the leak was on the floor and Mr. Coffer stepped in detergent because something Target did ultimately caused the detergent to be on the floor, that's a negligent mode of operation claim. But this, to say that the floor is shiny, is not a negligent mode of operation claim because, again, it has to tie back in to the dangerous condition. Ultimately,
What's your best case that stands for that proposition that you just described?
on negligent mode of operation,
Well, that the negligent mode of operation has to tie in or cause the dangerous condition to be on the floor.
take a look at Markowitz versus Helen Holmes. And the citation on Markowitz, let me see if I got it for you. No, I don't have it right in front of me, but Markowitz versus Helen Holmes is the Supreme Court case that is the negligent mode of operation claim.
We've got the site,
Thank you, Your Honor.
826 Southern 2nd,
Yes.
256.
Yes. And again, Markowitz was one of those post-Owens 768.0710 cases. Ultimately also, even if you do get to, and I'm only going to spend another couple seconds, even if you do get past this negligent mode of operation question, Target's position is that you still have to have some testimony from somebody to set that standard of care. We don't think he ever got there because the facts of this case demonstrate there was nothing Target really could have done to prevent this fall from happening. Ultimately, this spiller spilled this liquid within seconds prior to Mr. Coffer falling. The case law is pretty clear that with just mere seconds before an incident occurs, that there's nothing that the retailer can do. And to go the other direction, in effect, makes the retailer an insurer of the safety of the patrons. But even if you got to the floor, the question would be, was there any testimony from somebody that supports this argument that that tile and those lights fall below the standard of care. And that gets to the question of, again, whether the court was appropriately should have directed a verdict just on the standard of care issue. And we cited some cases to you, a couple of federal cases, Insurance Company of the West versus Island Dream and Thews versus Walmart, to say that you got to put on some expert testimony to demonstrate what's appropriate, because as Judge Gerber indicated, you know, a darker substance is very well illuminated on this floor. And so you have to weigh the argument of whether you should have carpet or whether you should have tile. We do have other arguments on if you don't turn this case over and reverse it as a matter of law, why it should go back, because there's some evidentiary issues. But we truly believe that this case gets turned over and reversed as a matter of law and directed verdict should have been entered. Any questions before I sit down and turn this over to opposing counsel? Thank you.
Thank you.
May it please the court, Jay Levy and Samuel Spatzer on behalf of the plaintiff appellees. I want to draw the battle lines clear for the court on this one, because I disagree with just about everything I've heard today, including the characterization of the record. As your honors know, we're entitled to view the evidence most favorable. I will submit to the court to start with that there were multiple witnesses. Almost all the employees from Target said it was very difficult, if not impossible, to see the spill on the floor, and that they frequently had people fall because there were clear liquids. Judge Gross, you hit the nail on the head in describing the plaintiff's case. To say that this was an aberration that's appeared in a brief of the appellee for the first time is simply incorrect.
How do you respond to the argument that it's necessary in a negligent mode of operation case to show that the negligent mode of operation caused the dangerous condition to be on the floor?
But we did have such proof in this case, okay? Here's what we have, okay? First of all, the negligent mode of operation theory is a rule that looks towards the business's choice of a mode of operation and not the events surrounding the operation. Here's what we have, and here's what we proved. We proved that this was a very highly reflective tile. We proved that the policy of Target was to have a highly reflective tile. We proved that they also had a policy of having a brightly lit store. We called an illumination expert who testified that based upon the way the light shine on the floor in a reflective pattern off the floor of these very bright lights, it was impossible to see the liquid on the floor. We introduced evidence in the form of Target's own policies that they wanted a wet look, high reflected floor. We had evidence that they buffed the floors every night. We had evidence that they had brightly lit floors. My expert went in, did an luminosity test, pointed out that there's an 88% reflective pattern, with 100% being the absolute total. And we proved that this was their policy. Coupled with that, we introduced 75 incident reports of slip and falls on clear liquids. So I would say to Your Honor that their mode of operation was that they wanted the brightly reflective floors, the high luminosity lights, and there was testimony that the reflection of the lights, and there were pictures introduced into evidence before the jury that showed the degree of reflection. So I say that was the corporate policy. The corporate policy as a resulted in clear transitory substances on the floor as being unable to be seen, and that was the mode of operation with the transitory substance on the floor that caused the injury. And I say that that's enough to prove our case, buttressed by expert testimony, and I believe the expert used the term based upon the way the store was laid out and how they did this was a camouflage effect. I think that is sufficient to have mode of operation. I too like the Markowitz case, because in Markowitz, what the Supreme Court was dealing with in that case was a grape that had fallen on the floor. And what had happened was that this was an elderly nursing home, well, a nursing home for elderly people, in which they allowed the food to be taken back to the room. It was foreseeable that somebody would drop a grape on the floor. And so the policy that was utilized was that the grape would be dropped on the floor, that the food would be taken back to the room, and somebody dropped the grape and somebody came along and slipped on it. It didn't matter about the grape. There was no contention that the person who dropped the grape was a Fabre defendant, as they contend here. But because of this policy that allowed people to be taking the food back, and because somebody dropped a grape in pursuit of that policy that caused the accident. Well, that's this case, kind of.
Well, here's what's bothering me. I mean, I'm going to be honest with you. I'm going to look at that case more closely. But in the way you've described the Markowitz case, I mean, that policy led, whether it's directly or not, to food being spilled on the floor. I mean, it's created that. Here, it seems that, there's nothing that they did. I mean, there's going to be spills in stores, because people have drinks or whatever, and those types of things. And what you're saying they did here didn't lead to the the presence of the dangerous condition. But what really, if you'd respond to this, what really bothers me is that what you're saying 100% goes to comparative fault. But if you don't have liability, we don't reach the issue of comparative fault. I get the comparative fault issue, but
I don't think it's a question of comparative fault. I think it's that would go to whether we should have seen it or not. I think if you set the underlying condition up so that it cannot be seen, which is what we say here, that's the mode of operation that leads to the negligence. I would cite to your honors the Disney World case that I cited in my brief. In that case, there was an issue of whether or not funneling the people off in a certain way to cross the street, which required them to go over a storm drain, could lead to a mode of operation. In that case, because they went over that, somebody tripped and fell, you could say that that was comparative fault because the lady wasn't looking where she was going. But in fact, the court held that because they were funneling them into this mode of operation to go over this storm drain, that was a negligence of Disney World. And I think that's the analogy.
In that case, their mode of operation caused them to, or had the people going over the storm drain, correct?
But in this case, the mode of operation has them walking on the floor.
Walking on the floor, but in that case, there's no, the storm drain is the storm drain. Here, there's the floor. It requires the spiller, the person that spilled it, to have walked through and spilled the liquid.
Well, but the spilling of the liquid and being on the floor is the foreseeable factor because that is the underlying condition that we're concerned with, Judge Kuntz. In other words, they had 75 accident reports showing identical conditions where people had fallen in the store. One could say that when you have that kind of notice of these kind of accidents, that you have a duty to maintain your property in a reasonable condition. And if you don't do that, then that's a basis for liability under premises laws. So I would say to Your Honor that this is a condition that they had knowledge of. This is a condition that they had to address, and the fact that that a third party came in and did the spill is kind of irrelevant because that's what they're supposed to be protecting against because they have knowledge and there's a mode of operation. And I want to just say that ever since the commencement of this case, back when the complaint was filed, it was alleged, quote, that Target maintained these light-colored floors with a clear, very high-gloss finish illuminated by bright overhead lights. An accommodation of these factors had the effect of making the floor surface very reflective, which made spills of clear and translucent liquids and other similar debris and substances undetectable. That's in the original complaint. So when he says we're springing this on appeal, I don't understand that. I would cite the court also to the Brisson versus W.T. Grant case, which is somewhat analogous to this one. In that case, there was a seat on a lunch counter, I believe, that was extended about 12 inches out into the aisle. It was unable to be seen because the color blended in with the underlying floor and the surrounding circumstances, and due to the bright light, it had a camouflage effect, kind of like this case. Held in that case by the Florida Supreme Court way back in the 50s, that was sufficient to allow for a mode of operation theory and to hold them negligence because that condition was set up by them.
the condition was, tell me what the condition was, like somebody did what? They ran into the
They walked into
extension
the
of the
seat
count?
because it was extended
Okay.
out into the aisle.
Okay.
Okay, that's that case. So I would tell the court that, with no disrespect for opposing counsel, that this case fits very neatly into the mode of operation theory. And I would also disagree with the interpretation that counsel has of the statute. I wasn't aware that that was a particular issue here, but as I understand the old statute, which was abolished, which was amended approximately 15 days after this accident, mode of operation was a valid theory of negligence under that statute.
And that's the statute you're operating under.
Correct. This court has held in a subsequent decision that when they amended, they did away with mode of operation. So this is, at this juncture, will probably be the last mode of operation case to come. So we're not talking about opening the floodgates for a bevy of people to come in on bright lights and floors. But this case was always tried on that way, and that's really where we are. Counsel hasn't gone into any of the other points. So I want to address the punitive damage question for
Before
a
you
second.
do, I'd like to ask you about the comparative
course, Judge.
Fault issue. What makes this case distinguishable from Markowitz is, in that case, it's possible that someone would drop the grape down as they're walking and not notice they've done that. There was testimony, though, in this case by the target employee that they saw the spiller cupping the detergent, as if that person knew it was in fact dripping. So isn't there an argument to be made that in the exercise of reasonable care, a person who knows they're spilling something is not just going to keep on going, but they would stay at the location, ward off others from stepping on it until an employee can come by and put little signs on the floor saying don't walk in this area or clean it up?
Is Your Honor's question to comparative or Fabre?
Well, the Fabre.
Okay. I would answer it this way.
I'm sorry, I misspoke. I meant Fabre.
I just wanted to be sure I was on the same page with Your Honor. Okay. I would answer it this way. First of all, there's a myriad of possibilities as to what could have happened. I believe trial counsel argued below that this was a question of inference on an inference on an inference. Where did he get it? Did he pick it up off the floor? Was he taking it to the front desk? We don't know any of that. And therefore, he said that there was no predicate to allow the Fabre defendant. I agree that that's a viable theory, but I prefer the theory that since the underlying condition upon which it's predicated is the actual spill on the floor, that can't be a Fabre defendant because that's what predicates the liability in and of itself. In other words, our theory of the case under mode of operations was because the lighting coupled with the floor hid the spill. The spill itself is a given and therefore shouldn't be a Fabre because that's what creates the very condition itself that leads to the mode of operation theory of negligence. I hope I answered, Your Honor. So I would say that this is not a Fabre situation for those two reasons. On the punitive damage issue, and I know that punitive damages are hard to come by, but when your policy demonstrates a gross indifference to the rights of others, this court has always allowed punitive damages to go forward. In this particular case, we had 75 prior slip and falls on clear liquids in this store. That did not include workers' compensation claims for similar accidents, and it also did not include people who weren't injured because they only filed an injury report when somebody was hurt. So if you had a slip and fall where there was no one injured, the amount of the accident reports, I'm suggesting, the amount of accidents on this situation could be much higher than the 75, and that was in the preceding 3 years. Yet Target did nothing. Target had a corporate policy, as proven by the evidence. At least 2 witnesses said this was policy, and we put in their manual, which showed their housekeeping policies, and they did nothing, and yet they fostered this. We contend that we had sufficient allegations supported by an evidentiary proffer that would allow punitive damages for gross indifference, reckless disregard of individuals. And when I read their brief in reply, it doesn't say that, it doesn't disagree with any of these arguments. What it says is we didn't prove our underlying case of negligence, therefore we don't get to the punitive damage case. But for the reasons I've said, I believe we have proven the underlying mode of operation cases. I would cite the Markowitz case, I would cite the W.T. Grant case, the Disney case, and I think there's one other that I wanted to, and the situation where, with the restaurant on some long name that I can't pronounce beginning with an O, where they had a situation with beer bottles that had fallen off, that they had a corporate policy not to put them on the dance floor, but they let them stay on the rail around the dance floor. A bottle fell and somebody slipped on it. So for all these reasons, we believe that the verdict and the judgment below is consonant with Florida law, and we think that it should be affirmed. We think the matter should also be reversed with regard to the punitive damage issue. Since counsel hasn't addressed the other matters that are, I'll stand on my brief on as to those. I thank the court for its time.
Thank you, Mr. Levy. Mr. Derer, rebuttal?
Yes, sir. Quickly. Let me read you in Markowitz, Judge Gross. This is Markowitz at page 261. In this case, the Markowitz's claim of negligent mode of operation specifically related to whether the presence of the grape was a result of the specific mode of operation chosen by the nursing home, i.e., allowing residents to carry food from the dining area to their rooms. In other words, under this theory, the grape was on the floor because of the mode of operation in which the nursing home permitted its residents to handle food. It's the grape. In the Disney case, it's the grate. If you look at, again, the Brisson case, the claim is that the seat had been raised in the extended position by an agent or employee of the defendant, or that the seat had been so elevated for a sufficient length of time to have furnished knowledge thereof, actual or implied, to the defendant or any of its agents or employees. Again, in Brisson, the seat is the dangerous condition. It's not whether you can see the seat, because I think honestly that goes to comparative fault, but the question is what is the dangerous condition? The dangerous condition here is clearly the detergent, because certainly Mr. Coffer would not have fallen on this floor. Millions of people walk that floor unless there was detergent on the floor. Ultimately, that is the dangerous condition. And if we go afield on this question, what we were doing or what we are ultimately going to do is give license to any claimant under the current statute to say, notice, constructive or actual, is not an issue because I couldn't see it. If we go in that direction, what we've done is we've just abrogated, eviscerated the statute altogether. There are a couple other cases. Wells versus Palm Beach Kennel Club, that's beer bottles. The dangerous condition is beer bottles. That's back in the 1950s. And the Ochalakni case that I think that Mr. Levy is talking about, again, that's beer bottles on the floor. There are other cases where if your mode of operation, again, allows the liquid to be on the floor, that's fair. But it's not the floor itself, and there are no cases that I'm aware of anywhere in the United States that ever have agreed that by itself a floor is dangerous. In fact, we've got case law in the state of Florida that says you can do anything you want with the floor unless you show that it is overwaxed or it's otherwise slippery. On the punitive damages issue, pretty straightforward question. The fact of the matter is these 75 incident reports are none of them are detergent. Some of them involve a fusee bottle, juice, milk, other stuff. So that wasn't evidence really of anything actually that ever should have come in front of the jury. But the bottom line is this is not a punitive damage case. The fact of the matter is that somebody slipping and falling on a floor is unfortunate, but it is certainly not punitive. Does the court have any questions? Thank you. Target would ask that you reverse the judgment and direct the lower court to enter a directed verdict of judgment in favor of Target. Obviously, if you don't go that direction, we have some other things. Oh, I do want to mention just really quick for one second. This interesting question again about the spiller. Frankly, in a transitory substance case, Your Honor, I don't think the spiller is an issue at all. This case just got so off the rails because of this question about what was the dangerous condition. Ultimately, if we are looking at a transitory substance case, the spiller is irrelevant because the question is, what did the retailer do to allow the substance to get on the floor, or under the new statute, how long was the substance on the floor? The question of whether it can be seen or not just goes to comparative, and the spiller is irrelevant. Thank you.
Thank you. Thanks both sides. Have a good day.
Thank you.
Next case on the docket, HSBC versus Sanchez. Yes.
Morning, Your Honors. Dean Morandi from Carlton Fields here on behalf of the plaintiff appellant, who I'll refer to as HSBC Bank.
It must feel great. I mean, you must feel like Tom Brady walking into Dolphin Stadium when you can file supplemental authority, which is pretty much on all fours. Is there anything that distinguishes that case?
Not at all. That was going to be pretty much directly where I'm going. The supplemental authority from the second district is directly on point. It accords with this court's recent decision on this matter, the Cabrew, if I'm pronouncing that correctly. That decision, the second DCA's parish decision, is directly on point with this issue. Just as here, in that case, they argue, or the trial court directly found, and they argued here, that in order to state an appropriate default, you could not allege default that occurred prior to the previous foreclosure action being dismissed. And in this case, it was a judgment. It's exactly on point. So unless the court has any reason to believe that should not be found any differently here, I think the parish case is on all fours with this case, and this court should go along with that case. Just to further enforce that, some of the decisions on point, the Bollettieri decision, which is also an on-point case, was taken up. That was taken up to the Florida Supreme Court, but then the Florida Supreme Court actually declined jurisdiction because it saw all the subsequent cases coming down, including this court's Cabrew case, if I continue to butcher that name. They declined jurisdiction because the case is on point. In this case, we know that the statute of limitations doesn't apply here because it wasn't pled and they agreed to it. We know res judicata doesn't apply here because they agreed that res judicata doesn't apply here. So what else could possibly apply here? And the answer to that is nothing. And in the end, we've pled a continuing state of default, which every court has agreed with. And now the second DCA has specifically shut down the exact argument that we were hearing here today, which is that Bartram somehow created a new doctrine under which if you have alleged a default that occurred prior to the dismissal of a previous foreclosure case, you lose, regardless of whether statute of limitations can be satisfied, regardless of whether res judicata can be satisfied. I would love to sit here and continue to talk, but it seems like my position is pretty clear. So unless the court has any questions on my initial presentation, I'll save my time for rebuttal.
Thank you.
Good morning, Your Honors. May it please the Court. Chase Jenkins on behalf of the appellees, Julio Ramirez and Gina Ramirez-Sanchez. Obviously, I'm walking into opposing counsel's supplemental authority. I believe, though, that Bartram still controls. Bartram says in no less than 4 different occasions that a refiled foreclosure action, the date of default that you allege, must be during the pendency or must be subsequent to the dismissal of that prior case. It cannot be during the pendency of that prior case. Bouveau also speaks to this. In fact, if you look at the underlying facts for Bouveau, the refiled case, the date of default alleged, was a date prior to the commencement of that first action. So statute of limitations, res judicata, I agree, they don't apply in this case. That's not what we're arguing. What was argued at trial, and I was the one who handled the trial, was that plaintiff did not plead a proper cause of action. The date of default that they alleged was a date when the loan was already accelerated. So there was no individual installment due. By alleging that in the subsequent action, my client and frankly any other borrower who has a standard form mortgage and a paragraph 22 and a reinstatement provision is left to guess as to what date of default then are they alleging that the client failed to pay. And that could impact statute of limitations, that could impact res judicata, that could impact your right of redemption, but we need to know specifically what date is being alleged. So I understand that there's this concept of you can allege a date of default and all subsequent defaults thereafter are not being paid. But if you strip away the date of default alleged in the second foreclosure action in this action, what you're left with then is this general pleading of some default occurred. We don't know when. We're not saying what specific date, so we can't calculate statute of limitations. We can't calculate right of redemption. We can't calculate whether res judicata would apply because that is very fact specific. So when you strip that away, what you're left with is just this general pleading that a default occurred. And like I said, I think Bartram is very clear. It says in 4 different occasions, the date of default in the subsequent action must be subsequent to the dismissal of the prior case. And that's not what appellants chose to do here. I think the remedy is simple. You either pick a date of default subsequent to that dismissal or prior to, or maybe some sort of hybrid where you say, this is the date of default, but here's how much we want to try to collect in damages. Here's the arrears that we want to try to recover from some sort of date. But they didn't choose to do either. They just picked a date during the pendency of the prior case. And that has a practical effect for borrowers as well. When a loan is accelerated, the borrower has essentially two options. Well, they have other options, but regarding bringing the loan current, they have two options. They can either completely pay it off, or they can reinstate and pay all their arrears. They can't just go and make one individual installment payment. No bank would accept that, or if they did, it would not be applied to the loan. It would just be put into a suspense account. So Bartram, I think, addresses this issue by saying, if you're going to try again, if you're going to refile again, pick a date that an installment is actually due, not when the entire loan was accelerated and there is no installment due. Does Your Honors have any questions for me? Okay, then, I thank you for your time.
Thank you. Any rebuttal?
Very, very small. Three very small points. We heard, as we saw in the we heard here today, as we saw in the briefing, with regard to the language of Bartram, where opposing counsel and the defense bar is suggesting that Bartram says in several places that we're talking about that it has to be based on a subsequent default. That's not the language in those are not the facts in Bartram. In Bartram, the lender actually agreed already that they were not going to be relying on any defaults that occurred prior to that dismissal. So those were the facts that the Bartram case was dealing with. So what they were saying is, of course you can allege a default that occurred subsequent to the prior dismissal, because those were the facts that were before the court. The bank acknowledged, and I'll quote, that it could not seek foreclosure of the mortgage based on the Bartrams prior default to the first foreclosure action, but could seek foreclosure based on defaults occurring subsequent to the dismissal of the first foreclosure action. Those are the facts of that case. Those were the facts as stated in the certified question. So Bartram certainly did not create this new doctrine sub silentio, suggesting that you couldn't otherwise rely on a default that occurred prior to the previous foreclosure action. Second point is that the borrowers would have no idea how to allege affirmative defenses. Clearly, they know what defaults that actually occurred in that regard, and they can certainly defend the case based on that regard. There's no due process issue here, and that question has already been decided by the numerous cases expressly stating that alleging a continuous default is appropriate. And I will close with, I just wanted to reiterate that we believe the relief here should be reversal and remand for entry in favor of HSBC Bank, because the trial court explicitly found, but for this Bartram issue, judgment would have been entered for HSBC Bank.
Did the court make findings as to damages?
It did not. I think it would be remanded for finding in relation to damages. All the evidence was before the court.
It made no fine. He didn't make the findings of.
He did not.
Okay.
The court did not. That is correct. Unless there are any further questions. Thank you, Your Honors.
Thank you both. Have a good day. Last case on the docket, candidate versus state.
Good morning, Your Honors, and may it please the court. My name is Andrew Greenlee, and I'm here on behalf of the defendant appellant, Marco Candidate. With me at counsel table is my co-counsel, Mr. Greg Rosenfeld. Your Honors, this case at its core is about the meaning of the phrase. Could I back up and reserve 2 minutes for rebuttal?
Yes.
I apologize. Your Honor, this case at its core is about what the phrase wanton disregard means. Our position is that the legislature knew what it was doing when it enacted the statute, that cluster of words, wanton disregard, had an established meaning, and that meaning was derived both from the law of torts and also that there are other criminal statutes that deal with wantonness. My friend on the other side resists the premise that the law of torts has any applicability in this case. We disagree, and there was a recent case from the 2nd District that was decided in January 5th of 2018. It's JC versus State, and I apologize, but I only have the Florida Law Weekly citation, which is 43 Florida Law Weekly D108A. That was a culpable negligence case, and in both the concurring opinion of Judge Solario and the majority opinion, they drew upon the law of punitive damages and tort, and it informs the analysis of the conduct at issue.
But do you really need to go there? You've got this style case that you've cited in your brief, which was not even responded to in the answer brief, having to do with that there had to be some kind of evasive maneuver or some indication of danger to the other vehicles on the road.
Right.
And the state simply didn't introduce any evidence to suggest that, other than the fact that your client, went into moving traffic without having stopped as he approached the main artery, that any car took any kind of evasive action. No one called 911 to say there's a madman loose on the road and nearly hit me. Why can't you just rely on that?
Well, we'd be happy to rely on that, and if your honors want to rely on that, we would welcome it. And we do think that style case is, the analysis is the analysis that this court should take. The wantonness, what it means to be wanton, it refers to
there's criminal, it's pretty well defined in criminal law, but is there any dispute in this case that it was your client that made the 911 call?
No, and in fact, it's funny, I was discussing this with co-counsel. He appeared to try to make this fleeing and eluding as orderly as possible. He called himself 911 and said, hey, I'm not comfortable stopping in this particular place because it's poorly lit and I have a fear of law enforcement. I am going to drive to this store, and law enforcement, both officers conceded that was the case. So it's not the sort of case where he is recklessly barreling into traffic, going up on sidewalks, making wild U-turns that put other people's lives in danger. And that's what wantonness, really what it goes to, is the likelihood that somebody else is going to get hurt. And there was absolutely no testimony as to that particular element here. If you look at the actual intersection, and there doesn't appear that he even needed to make a stop. Now, so he goes into the intersection. It appears that he did exactly what the law permitted in that respect. There was some testimony about weaving. Your honors, if you live in South Florida, weaving through traffic is the norm. There's nothing wanton about weaving through traffic. Yes?
So I get the thing. This was on Cove Road, that's like in Martin County.
Right.
And so was this, that Cove Road, correct me if I'm wrong, because I'm not positive, but does that bisect US 1?
It does. Federal highway is US 1.
Okay, and so was your client east of US 1 and came in from the parking lots there? Was he east of US 1?
He was traveling westbound on Cove Road. And he was traveling on Cove Road, and I think the testimony was that law enforcement made a U-turn and began to tail him. They noticed that there was a tail light, a license plate light that was out. Our client cut across a lane of traffic to make a right onto US 1. Came around, and at that point, the officer activated his siren. Our client went, and it appears that he was going to pull over into the bank, Seacoast Bank, and he just wasn't comfortable with the lighting that was there. The testimony was that he was, as a black man in America, he had a fear that law enforcement might...
At that point, he was on the phone with the 911 operator?
It's unclear exactly what point the 911 call... It's clear that it was after the sirens were activated. But at some point after the sirens were activated, he called 911, and he said that he reported it himself. I am fleeing right now. I'm going. I'm not I'm uncomfortable with the lighting, I'm going to drive to a location that's better lit. We know from I think in their best argument is that attempting to go on to re-enter Cove Road was somehow in the words of the officer, it was done without due regard to the property of other people. We know, though, from this court's decision in National Car Rental versus Holland, 269 Southern 2nd, 407, that you could blow right through a stop sign and cause a collision, and that would be ordinary negligence. That doesn't rise to the level of wanton disregard. Again, wanton disregard is, you know that, and I would refer the court to the standard jury instruction 28.5 in the reckless driving context. They define what wanton means, and it is conscious and intentional indifference to consequences with the knowledge that damages is likely to be done to persons or property. So it's this likelihood that damages is to be done to persons or property that there was no evidence whatsoever on that particular point. All there was the good analogy is, I think, the Steele case where there was, other cars where there was no evidence that there were other cars that were either had to swerve to avoid or that there was any type of danger caused to other people, and that danger was consciously disregarded. If your honors have no further questions, I'll reserve the remainder of my time.
Thank you.
Thank you. If it pleases the court, Joseph D. Coronado Jr. on behalf of the state. I just want to clarify a couple facts here initially before really getting into the case law. What we have is to clarify your question earlier, Judge Gross, he was east on the westbound side of Cove Road. So he was east of US 1, heading westbound. And he was in what we'll call the center lane, a right lane being the turning lane heading north onto US 1, which is a very busy intersection. There's a Publix, a Bank of America, all kinds of strip malls there and everything else. The police officer is northbound, I believe, on US 1, on the other side of the light. So if you imagine an intersection, he's facing this way, the defendant is facing this way. They're looking like this. The defendant crosses over, almost in an evasive manner, crosses over the middle lane, turns right onto northbound US 1, at which point in time the officer sees his rear license plate light out, thinks it's suspicious, lights him up, lights are on. The defendant pulls into Seacoast Bank, which is a kind of a weird bank set up there. It has an entrance.
It's north of Cove Road, correct?
Correct. It's literally right on the corner there, so it's just north of Cove Road. You can access it both from westbound Cove Road and northbound US 1. He pulls into there, and he almost kind of hints like he's gonna stop, but he doesn't. He accelerates through the parking lot, which is a long S-curve parking lot, and proceeds right through the intersection there.
What do you mean when you say intersection? There's a parking lot that goes out and empties east of the intersection.
Correct.
Right. So you're talking about, the place east of the intersection, because that's where.
There's multiple intersections here, so I'll clarify.
Well, I know, but in other words, like an intersection is two cross streets, but there's a driveway that you would go to that you would access the bank from on
yes.
Cove Road. And so my understanding is that he went out that driveway onto Cove Road. Right?
But that intersection is a little strange intersection. So you actually have to cross, in order to go the direction that he was going, which was eastbound. So he's got to cross over the westbound side of traffic going west.
Got you.
Although a permitted turn, he doesn't stop, which is in violation of, which I did not cite in my brief, and I apologize for that. It's a violation of, let me see where I got the, section 316. Florida statutes 316.125, vehicle entering a highway from a private road or driveway or alley or building of a business must stop or yield. I think it's a
I mean, we live in South Florida. I mean, obviously, stop signs go down, they get stolen. I mean, that's why the Florida legislature put that statute into place, was because there's not always a stop sign and a dangerous exit from a
Okay,
driveway.
this is what, here's my problem with this case. If there was enough traffic on the road, you know, like to really turn this into a reckless driving case, it seems that the most reckless person then on the road was the police officer who executed the stop. In other words, like, that's the thing that I find, you know, really unusual about this case is it was such an aggressive form of stop that if there was all that traffic on the road, then it seems that the officer was the one who should have charged himself.
Well, underlying this is a BOLO. There's a BOLO out for this guy, which, you know, kind of goes a little bit soft-spoken in the case. But two, what you have, the officer kind of is faced with a situation where this guy's fleeing, he knows there's a BOLO out for him, and he's faced with a relatively dangerous driveway exit here. He has to weave through traffic.
Well, there was no accident. There was no accident there, right?
Yeah, but why do you have to have an accident?
Well, there wasn't. I mean, it would have made a difference. It's another fact that
Right.
leads to recklessness, but there's no accident. So, I mean, you know, that's one thing that didn't happen. And what's the precise description of weaving through traffic? In other words, what are we talking about here? He passed one car, or somebody was making a right turn and he went to the left of them? And, I mean, what's the precise description in the record?
I understand, and I could read the record for you.
But if you can just recall generally the testimony.
I mean, generally it's exactly what we said. He accelerated through the S driveway, proceeded directly through without stopping, weaving through the traffic. So it wasn't necessarily I don't think it was a straight shot necessarily, but he had to avoid some cars such that the officer had to stop himself. The officer
Just
couldn't
saying
proceed.
weaving doesn't necessarily mean that he had to avoid cars. I mean, you could theoretically be weaving through the traffic in a perfectly legal manner. I mean, to show, I agree there doesn't necessarily have to be an accident, but, I mean, wouldn't there need to be weaving and causing other cars to take maneuvers to avoid an accident or something? Because just weaving could be putting your right blinker on, getting in the right lane, and 5 seconds later, putting your left blinker on and getting in the left lane.
Well, I think that's, well, one, Judge, we're here on a JOA, so I think that we're allowed the inference that their cars were essentially affected by that, by saying that weaving is going on. Two, you have the officer stopping, so the officer's kind of comparing and contrasting it. He's saying you're weaving through the cars.
Did he say that the
but
other
I couldn't
cars
go
were
through.
impacted, or did he say that he was weaving through the other cars?
He said he was weaving through traffic. He weaved through traffic, I think was nearly a direct quote.
You know, you made an argument that there's an inference to be made. I'm not sure that's the case. Either there's proof put on by the state as to what the cars actually did or had to do, or there's not. The inference would be what the defendant's intent may have been in his driving, because no one's going to testify to that. But to say there's an inference as to how other cars were affected, I don't see how that's a reasonable inference to be made without facts to support it.
Well, I think the inference is compared and contrasted to a certain extent. I think if you simply just say weaving without knowing what the officer then said afterwards, which was, I had to stop. So if you look at that, he's driving and weaving through traffic, sufficient to say that the officer felt that he was in danger or somebody else was in danger if he proceeded through that, over the highway, cross path, intersection, whatever you want to call it. So I think in that
As
sense.
Mr. Greenlee said, this is South Florida. People pull out in traffic all the time, and you
doesn't
say
make it right.
you say no, but it doesn't necessarily make it aggravated fleeing and eluding either.
Well, if you put the entire totality together here, I think you do have it. I mean, he's not stopping under any circumstances. I mean, he might be on the phone talking to dispatch saying, I'm fleeing and eluding, but he's going away from the congested area. I mean, that is a very well-developed area, and he's traveling in the other direction at 40 miles an hour away from the officer. He's not submitting to the officer by any means. He's clearly trying to get away.
I mentioned earlier that your brief did not respond to the Steele or Style case, which was mentioned in the initial brief. Just wondering why that was and what's your response to the case.
I didn't think it was significant enough to really kind of address it because it didn't actually discuss wanton disregard. It was mostly a case that was discussing whether or not the lights and sirens are on sufficiently to constitute the fleeing part. There was an admission essentially to that by the officer that the lights and sirens were not on to avoid he didn't have his sirens on and the lights were malfunctioning with his traffic car. I think the more applicable cases would be Luvic, which is a 4th DCA case from 1997, as well as Your Honor's case, Judge Gerber, your case, Damas, which essentially kind of was the same issue as Style, but I think you rather artfully put in there kind of the hopping of the curb and the driving around. I mean, that wasn't necessarily extremely reckless, but the court didn't overturn anything there. I mean, there wasn't any. The behavior in that case, which was pretty well settled, is very similar to the behavior in our case, and we do have a marked car in our case. So.
You don't know, was there a lesser on the fleeing and eluding charge? There's the fleeing and eluding, willful and wanton. Was there a lesser included offense that was submitted to the jury?
I believe, I'm not quite sure on that, Judge. I don't remember off the top of my head. I apologize for that, but I think it was reckless driving. But don't quote me 100% on that. I have to go back and look for you.
Okay.
If there are any other questions, the state would ask you that you affirm.
Thank you. Rebuttal?
Mr. Greenlee, were there lessers submitted to the jury, lesser included offenses of the reckless driving, the
My
fleeing?
recollection is consistent with my friend that there was a reckless driving. I don't know 100%, but that's my recollection as I sit here today. Your Honors, with regard to the violation of the statute that was referenced, it wasn't referenced in the briefing. It wasn't referenced below. There was no stop sign, at least as far as I could tell. And even if the statute applied, blowing through a stop sign, we know from Holland, that's not enough to constitute wanton disregard, even though in Holland, it caused a collision in which someone died. So our position is that there has to be some testimony that other cars were affected, or alternatively, that the conduct caused such danger that it would rise to the level of punitive damages. And it's funny that one of the earlier cases was about punitive damages, and the trial court, I think correctly, found that there were 75 different slip and falls, and they were on notice, and that wasn't conscious disregard for the risks. Punitive damages is quite a high standard to meet. And Your Honors, there is this is in connection with the culpable negligence statute. But in State versus Green, which is a Florida Supreme Court case, and I have the citation here, it's cited in the J.C. versus State case. That's what brought it to my attention, that recent 2nd District case. It's at 348 Southern 2nd 3rd, and the quote is in Judge Solario's concurring opinion, quote, "The degree of negligence required to sustain imprisonment should be at least as high as that required for the imposition of punitive damages." We're talking about taking somebody's life away for as long as 15 years. That's the maximum penalty for this. So we think that there would be quite serious due process concerns if the standard in the law of tort were somehow not as high as in the standard for criminal law, when you're actually talking about taking away somebody's liberty interest. And in addition to that, a person has to know what the law forbids. There are serious due process concerns here if there were any difference between what wanton disregard meant in the law of tort as it meant in the law of the criminal law. I wanted to make one more point here. Yeah, with regard to the inference that can be drawn from the testimony, we can't stack inference on top of inference. Somebody has to actually testify that other cars were actually affected by the conduct, or that there was some sort of grave danger that was created by the conduct. Your Honors, with that, we would ask the court to reverse the decision below and remand for the imposition of the ordinary fleeing and eluding charge. Thank you very much.
But is that the lesser? In other words, is there a lesser? That's why I asked you about the lessers. You said the only lesser was reckless.
I think within the statute, in I think the Steele or Style case, that was what the remedy was. If it wasn't the elevated form of fleeing and eluding, the proper remedy was to reverse and remand for the imposition of the ordinary fleeing and eluding.
But does it have to be one that the jury had the option of finding? That's the question. In other words, like in that case, my recollection was that it was a lesser that may well have been charged.
Right, right.
The jury didn't have the option of finding that. Does that preclude us from reversing in that way?
Your
Okay,
Honor,
we'll figure it out.
I don't know the answer to
Yeah, I
that
don't-
question, and
okay.
I apologize
All right.
for not being prepared on that. But I don't know. I mean, I know what happened in that Steele case or Style.
We'll look at it. We'll figure it out.
Okay. Thank you very much, Your Honor.
Okay.
Thank you all both very much. Court's in recess.